So in a CIPD a survey and report in 2019, the cost of workplace conflict was assessed. Starting first of all with the average cost of recruitment, and bearing in mind these are 2019 figures, they may have increased with everything else, increasing over that time. Average cost of recruitment is £5,500 per employee. The average cost of sickness to a business per employee per year is over £500. And the average cost of management time for dealing with a formal grievance that might be raised in a situation of conflict is just over £1,000. And the cost of dealing with a disciplinary case can take up to, on average, 6 days of management time. They can, of course, go on for much longer. Average cost of employment litigation is between £5,000 and £10,000, and once litigation has started, the average cost of settling a claim was £5,000. So those figures give us a stark picture of the cost to business, and those are average figures. We can, of course, come across cases that go well beyond those figures. So the cost of getting it wrong or allowing problems to creep in and spin out of control can be very high. So the purpose of our webinar today and the series that follows over 3 other webinars is to give us an overview of these 3 key areas of HR which help us to get ahead of problems. Our title is Recruit, Retain and Release because we've identified from many years of experience of advising businesses and individuals that it is good and effective management of people in these 3 areas and of processes and of paperwork that can help employers get ahead and manage problems and enable employees to thrive to produce productive workforces. So I'm going to hand over to Isha to just run us through what we're going to be covering today.
I think you're on mute there, Isha.
Oh, thank you.
Sorry. Can you hear me now? Okay, so the agenda for today is that we're going to run through what Birdie Law is all about, and then we're going to talk about recruitment, then retain, release, and then at the end we'll have some questions, and then there'll just be a bit more information about our further webinars. So Birdie Law, we're a niche law firm based here in Birmingham, and we specialise in HR and employment law, intellectual property, commercial and tech. And the firm is made up of Liz, so she's our employment law specialist. There's Des, who leads on intellectual property and commercial. And then there's myself and Reese, and we're paralegals who assist Des and Liz. And our key values are that we put people first, we're collaborative, straightforward, and we embrace change and challenge. So firstly, we're just going to do some questions to test your general knowledge on employment law and particularly the recruitment side of it. So if you have answers to the questions, could you just pop them in the chat? So the first one is, in the UK, under the Equality Act 2010, is it legal for an employer to ask a job candidate about their health conditions during the initial application process? So A, yes, in all circumstances. B, yes, but only if it's necessary for the role. C, no, if it is not legal in any circumstances. And D, only after a job offer has been made. So a few people are saying A, a few people are saying B, D. I'll just give you a couple more seconds to answer. Okay, so the majority of people have said B, but the answer is actually D. It's only after a job offer has been made. And under the Equality Act 2010, employers generally shouldn't ask candidates about their health before offering them a job. And then moving on to number 2, which of the following is a characteristic of a 0 hours contract in the UK? A, guaranteed minimum hours of work. B, the employee must accept all work offered. C, no guaranteed hours of work, or D, all of the above. Yes, so majority of people got that right, C. There is no guaranteed hours of work if you're under a 0-hour contract. And then lastly, number 3, employers in the UK are required to provide written terms of employment from the first day of the employee's start date. Is that true or false? Yes, so everyone got that right. It is true. Since 2020, employers must provide employees and workers with a written terms of employment from their first day. Before it used to be within 2 months, but it changed back in 2020. And back to Liz.
So it's good to know that you're all up to date with UK employment law. That's very a positive place to start. So we're going to start thinking about recruitment in this first part of the webinar, and bear in mind this is an overview, so I'm going to be going quite fast and I'm going to cover some key areas in not a lot of detail, but bear in mind that our next webinar, which I think is happening on the 6th of December, we will drill down into the area of recruitment in more detail and look at these things in a much more granular way. So we're going to look at how to hire well. We're going to look at a little bit about employment status and the rights that go with it. We're going to look at compliance and contracts and background checks, because these are all key areas for recruiting well. So hiring people is fundamental to long-term success. The advent of AI and the digitalisation of the world will not remove the need for good teams. People within business are going to be fundamental in maybe in different ways, but they will remain fundamental to business growth. So we know that bad recruitment and bad recruitment processes can leave businesses with problems, not just potential legal claims if recruitment's done badly, but the wrong recruits can cause a lot of aggravation for business. I've read out the stats, but we can think a lot about the time that needs to be invested in trying to turn people around and in dealing with the fallout from disgruntled employees, poor performing employees, absence. So we're going to move on now to look at hiring well. Next slide, please, Isha. I don't seem to have that on my... Can anybody see the next slide? I don't seem to have it.
Yeah, I can see it.
Thank you.
Great, hiring well.
So hiring well really is about 3 things. But before we get on to those 3 things, there are 2 questions. Why should we hire well? Why should we bother? And how? Well, the why goes back to what I've just talked about. Getting it right at the beginning of the employment life cycle really does start with recruitment. It doesn't start with day 1 of employment. Getting the right people and understanding why we are recruiting to the roles that we've identified and how that aligns with the plan for the business and the future of where we're heading within that plan is critically important. The how really follows on from the why question. It's all about priorities, process and paperwork. Now, these 3 Ps, I think, can be carried through to anything else we're going to be looking at in recruitment, retention and release. And I think it'll be a theme that continues to follow us throughout our webinar series. Under priorities for recruitment, any business needs to be clear about why recruitment is happening. Why is it we're trying to expand a team? What we're trying to achieve and who the business needs to recruit. And this is less about the person we're looking for and more about the role and why it's needed. Is it that we don't have the right skill set to align with the business plan and the direction of the business? Are we trying to diversify into areas that require different skills? Are we developing products or processes that require different skill sets, different experience? Are we an early stage business led by founders who are very good at developing the early technology or product service offering, but who don't have the right skill set, the right experience to take the business forward into the growth phase that it's heading into? Are there gaps because of people leaving or because of the development of our existing workforce that we need to fill? Are they short-term or are they long-term gaps? So once we've identified those priorities, we now then need to move on to our process of the key steps to successful hiring and making sure that it stays compliant, and our paperwork will follow on from the process. Next slide, please. So I've covered this in a little bit already. Why are we recruiting? Does it have something to do with business growth? Is it to infill for a specific project? Is it to do with diversification into different markets or different product service offerings? Or is it more of a short-term requirement? What do we need to recruit to fulfill the why? What is the business plan telling us? Where does the role fit? And have we put together a job description? Is there one for an existing role? Does it need to be updated? Or is this a new role? And if so, what is it that the business needs within that role? Before we get anywhere near advertising, our job description is the first place to start. And once we have outlined what we need for the business in the job description, we must move on then and only then to our person spec, which identifies the skills and experience, the qualities, the abilities, and the values that will go with the person that we are looking for to align with our business. Next slide, please. So moving on then into the process and the paperwork, the nitty-gritty of what steps we need to take to recruit well. The process is a fairly long one that involves several key steps. Once we've done our job spec and our person spec, we need to advertise. We need to work out where we're going to advertise in the right places to find the people that we need, and that will depend very much on the role that we are advertising. Our shortlisting process is extremely important. We don't want to waste our time interviewing people who are not going to be right for the job. So scrutinising the applications, working out whether those applications really do align with the job spec and the person spec, and then moving on to assessments and interviews. Those two steps are really key in your recruitment process, and I think they deserve a huge amount of time and investment to get things right, to make sure that you are going to be offering the role to the right person for the long term. Your decision making, your offer letters and rejections, taking up references, carrying out right to work checks and other pre-employment checks, and then issuing contractual paperwork and putting in place the framework around the employment, such as payroll, making sure you have employers insurance if this is your first recruit, dealing with pension and other benefits that you are going to offer. Then moving on to the paperwork that aligns with this process, we're thinking about key documents such as the offer letter, the contract of employment, or the paperwork that confirms the engagement if this isn't an employment relationship, keeping evidence of right to work checks, making sure that you're dealing with matters such as privacy notices for your employees or workers, working time opt-outs if you're going to be requiring people to work beyond the 48-hour limit, or indeed if they've got several employments going on, making sure that you have some basic employment policies in place, and dealing with the retention of recruitment records to make sure that you're staying compliant with GDPR and the Data Protection Act. Next slide, please. It hasn't moved on. No, there we are. We're there. Yep, thank you. So thinking next about employment status and why that matters. We deal with a lot of businesses which are in the early stage, and they are bootstrapped founders who are frankly glad to have any manpower that they can, that's offered to them. So often, you know, friends, fools and family, people start working in the business very informally. They might be doing so under sweat equity arrangements, and relationships develop in a haphazard manner. There's very little process and there's very little paperwork. Those of you who work or have worked in large corporate organisations know that that is very far from the case, that policies, paperwork, processes are all in place and everybody's clear about their role and their relationship with the organisation. I would always say to any SME, be clear that you understand the different types of employment status. And in law, there are three that are relevant, and only three. They are the statuses of employee, worker and the self-employed. And those three different statuses come with different rights and obligations. The highest of them is the employee status. Employees who work under a contract of service, we usually call it a contract of employment, owe the highest obligations to the business, and the self-employed individuals who might work as freelancers or consultants or contractors do not work under a contract of employment. They run their own business enterprises and they generally invoice for their services, and they owe very little obligations legally to the business. And this hybrid of worker in between has, as you can see from the grid on the right, a number of employment rights, but there are some very key obligations that they don't owe to businesses that they work in, and we will come on to look at that in due course. Thank you. Moving on. Compliance and contracts. The key thing to know here, as we said in the quiz, is that all employees and workers must have a written statement of particulars of their employment or engagement, and these need to include, by law, a certain types of information. We usually call this an employment contract when we look at employees, but for workers who might include casual 0 hours workers, that written statement of particulars is still required even if we're not issuing an employment contract. So we need to make sure that we've given the right information by day 1 of their engagement. On the right, in addition to the legal requirements, there are some optional things that employers really should be considering in any engagement with a worker or a contract of employment, and those are around confidentiality of key business proprietary information, the use of notice and garden leave to protect the business when the relationship comes to an end for an employee, the use of restrictive covenants to stop competitive behaviour when people move on, and the important asset of the business in relation to intellectual property, the things that employees or workers are creating that the business wants to own. And the law on intellectual property does distinguish quite clearly between employees and workers, and it's very important that small businesses understand that and have the appropriate protections in place in their contracts. Apologies, you can hear a phone ringing in the background. We'll just let that ring out, I'm afraid, or Isha can stop it. We're going to move on to the next slide. So very briefly on background checks, every employer having staff work in their business must carry out a right to work check regardless of the size of the business, and there are large penalties that businesses will face if they fail to do that, or if they don't get the right evidence in place. The other checks and balances that employers generally look to use are references from previous employers, although they have a very small value these days because of the law around and the risk around giving references that might be inaccurate or in some way misleading. DBS checks if the individual is coming to work with vulnerable people or children, and there might be conditions around evidence of qualifications. There might also be visa requirements when the right to work checks have been carried out. So those will all need to be dealt with before the employment offer can be made or the contract can be taken up. Next slide, please. So I think Isha's going to ask you, we're going to move on to retain next, retention for people, and Isha's going to ask you some quiz questions.
Thanks, Liz. So yeah, the first question we have is, in the UK, employees have the right to request flexible working after 26 weeks of employment. Is this true or false? You can pop answers in the chat box. Selena, I have seen your question as well, and I'll note it down so Liz can answer it at the end. So half of people said true and half of people have said false. The answer is actually false. Employees have the right to request flexible working after 26 weeks. That's not correct. Sorry, the answer here says false, but then it agrees with the statement.
Oh, it should be true then.
Yeah, true. That was, sorry, I wrote it down wrong. It is true. Number 2,
Sorry,
which of the following
oh.
is not a protected characteristic under the UK Equality Act? So is it age, marital status, religion or belief, or sexual orientation? Yeah, so the answer is actually B. A few people have said age, but it's actually marital status. And then lastly, what is the minimum notice period an employer must give to an employee who has been working for them for 2 years? Is it 1 week, 2 weeks, a month, or 2 months? So most people have gone for 1 month, but the answer is actually 2 weeks. That's the statutory notice period.
Robert's doing
That
well.
people
There are
have
no prizes, by the
employers
way.
have to give. Just a pat on the back. So I'll hand back over to Liz, who will go through the retain section now.
So, retention of people is more than just about notice periods, but that was a little bit of fun to check if our brain cells are working, and some of them are brilliant. But it's interesting, isn't it, how we can be misled into certain conceptions about what is legally required versus what's optional and what might go into an employment contract. So we'll come on to look at that in more detail in one of our future webinars. So we found the right hire. We've done our recruitment process well. It's day one of employment. It's really crucial now to get things right from day one to evaluate their future in the business. And as those of you who have been involved in recruitment and management of people in the past will know, just because somebody is offered a role doesn't mean they're going to be successful in the role. They may have sold themselves very well at interview, and depending on your interview and assessment processes, you may not have got to the bottom of some of the issues that may become apparent once they start work with you. And I would add on that, just because you get a reference from a previous employer that says they're great doesn't necessarily mean that's going to be your experience of them. And that's one of the reasons why I think references have very limited value, and why effective and rigorous recruitment processes are more important. But on the flip side of that, people with lots of potential can help your business grow, will help your business grow. They will help you get to the next level if managed well, if incentivized. It's really important to make sure that we are managing both the good and the bad, the positive and the negative well, to build for the future. And as employers, I think we have a responsibility, and I count myself amongst this. I'm a small business with employees, Isha's one of them. We have a responsibility to the people that we offer employment to make sure that they are trained and developed. And if they're not hitting the mark, to help them to improve, help them to work out what they need to improve. Making sure that we're clear with them about roles and responsibilities. And in a very competitive recruitment market for employers, where millennials and Gen Zers are not loyal, they will go where they feel is best for them, and they will not hesitate to move on. It is so crucial to keep our star performers, to incentivize and to keep them engaged and interested in their roles and in the future of the business. And unfortunately, for some, it will mean failing fast. It will mean having to get to grips with issues that are not right, whether it's from day one or whether it's things that creep in, and taking responsibility as the employer to manage those issues. And with responsibility comes control and a mitigation of risk. So if we could move on. So just on the sort of broad picture, training and development looks like and making sure that people are properly trained for the role, making sure that you're clear with them about the training you expect them to undertake and how that's going to shape their role, whether it's going to hold them back if they don't succeed with the training, and having development plans and goals in place for their future direction. And if they're in a probationary period, you might want to have a training and development plan for that probationary period, for example, and then once that's passed, you move on to a new training and development plan once their employment's confirmed. It also looks like having regular performance reviews, and by that I don't mean annual appraisals. Annual appraisals are really an at a glance meeting once a year to overview the year. They are not the place to undertake reviews of day-to-day performance. And unfortunately, my experience tells me that many businesses, and this is not just small businesses, large businesses too, fail at that hurdle. When they come to me wanting to deal with a poor performer, there is no track record of reviewing performance and dealing with issues as they crop up. There is only evidence of annual appraisals. Next slide, please. So being clear at the start about roles and responsibilities really means having these clear in their contract of employment or their worker engagement and their job description. It also means making sure that description and the contract stay up to date. So if there are any changes to their role, new duties, a change to job title, a promotion, so sideways or upwards move, a change in their working hours, their working pattern or their pay, additional benefits, that these are recorded as contractual changes. And that their job description reflects that the job that they do as it evolves. All too often, the job description remains as it was on day one in the offer of employment, and so does the contract. And that can mean things go adrift. So any changes to contractual terms that you want to make as an employer, particularly if they are not in favour of the employee, must be agreed in writing. So if they're imposed, that will create legal risk. You need to make sure that you are going through a process of getting employee agreement, and that's recorded in the contract or in writing somewhere. And it's also fundamentally important that people understand who they report to and who's monitoring their performance and how that's going to be done. And the best way of doing this is to make sure it's all set out at the start. Moving on. I've mentioned key KPIs there. We may all be familiar with the term. If we're not, it stands for Key Performance Indicators. These are important in any role for any individual to understand how they're doing in their job. And for the role and for the business, the key performance indicators will vary. It'll depend on what the business does and what contribution the individual makes to the business performance. And data will be important, so measurement of KPIs will be important, and examples of things that can be used to monitor individual performance as well as company performance can include client satisfaction, reviews, employee retention, employee turnover, revenue growth, and cost reduction. So KPIs we will drill down more into in a future webinar on retention, but those are things to consider building into performance and personal development plans, so that there are smart objectives, smart goals to track progress against. Retaining talent really means investing in performance and career development. It means developing skills that will give your business a competitive advantage. It means looking at short-term versus long-term objectives for the business, for the roles, for the individual. And it means aligning individual performance and development with salary expectations, and also understanding what the market is doing on salary as well, not just what you think is right for your business, so that you can understand if you are looking to keep key people, what their expectations could be elsewhere if they were to move. And ensure that their development plan and their performance plan is aligned. So moving on to the less positive side of retaining people, and that is what if people don't measure up. Either it becomes very quickly apparent from day one that they weren't what they said they were going to be, or there are difficulties around them bedding in, aligning with the company culture, performing the role that you thought they were skilled and experienced and up to performing. So there are two aspects to this. There's day one, failing fast, and there's people who perhaps get on great for a while. They're doing their job very well, but things start to go awry further down the line. So I'm going to deal with, on the left hand side of this slide, probationary periods, dealing with performance that's poor from day one. Niggles, people just aren't right, things aren't going right. So probationary periods are generally used for the first 6 months of employment. And if you're going to use it for a new recruit, it's key that this goes into the offer so they're aware that their employment is conditional on a probationary period, and it's reflected in their contract of employment. Now, very often, employers don't make good use of probationary periods. And the reason why they don't is that they steam ahead and they forget about reviewing performance within the probationary period, within the 6 months. And what tends to happen is that the employer gets to the end of the probationary period, 6 months comes along, and they don't like this person that they've recruited. They think they're doing a bad job and they want to end things there. And I want to say to you today, well, technically that is legally possible, but I think it's really poor practice, and I don't think it helps any business to not review performance during probation. Firstly, it helps the individual, the recruit, to know how they're doing. Secondly, it will get ahead of brewing problems, which can be fixed with some training, coaching, mentoring, a little bit of investment of time, and might lead to a success. And thirdly, I think it's really unfair on somebody to come to the end of a probationary period to be told you're not up to the job when nothing's been discussed with them prior to that. I also think it then creates a possible avenue for somebody to accuse the business of discrimination, which could give the grounds for a legal claim against the business, even at 6 months of employment. So carry out reviews, I would suggest no less often than monthly. Confirm at the end of the probationary period, the outcome of the final probationary review must be confirmed in writing. You can extend it, but be clear about why and for how long and what's expected at the end of that extended period, and don't keep extending it. Address any performance or conduct concerns early, not at the end. So assuming somebody's got through their probationary period, they go forward, they're a happy, contented employee, you're happy with them, but then something happens or things start to develop and there are concerns about their attitude, their delivery, their productivity, their performance, their relationships with others. It could be a whole host of things. Then you would need to start looking at a formal process. And quite early on in that process, my advice is to consider whether this is conduct or capability. And the reason I mention those two words is because they are potentially fair reasons for dismissal. And at the beginning of any process, you need to have in mind the end point. You cannot assume that the process is going to lead to everything being resolved. It could end up in dismissal. And if they have over 2 years continuous employment, they'll have the right to claim unfair dismissal. To defend that claim, you'll need to have a fair reason for dismissal, but also show that your process was fair and reasonable. So get ahead of it, plan it out at the beginning. Be aware of claims that could be brought against you with less than 2 years employment. Those are typically around pregnancy and discrimination, but particularly disability discrimination where health issues are relevant. And in unusual cases, but becoming more common, whistleblowing for company wrongdoing, that kind of thing. In terms of a process, what does a good process look like? A minimum process must follow the ACAS Code of Practice. You can find that on the ACAS website. We can share a copy of it with you after the webinar if you'd like a copy. And the process outlines some basic steps, and they're common sense steps about running a process which is effective and fair. So it's about raising issues promptly, not delaying, having meetings before decisions are confirmed, making sure you act consistently in decision making, establishing the facts if this is a case of misconduct or performance, informing employees so they understand the basis of the problem, giving them an opportunity to respond, defend themselves, allowing them to be accompanied at meetings, and allowing an appeal against the decision, whether that's dismissal or a warning. Next slide, please. Absence management, I've put a slide together on this just because it comes up so often, whether it's persistent absence, a day here, a day there, or something more long term. Managing absence is tricky. More and more we are seeing disability discrimination creeping into claims on absence management, because people know that to bring a disability claim, the legal definition of disability is not the same as the definition that the benefits agency applies for benefits or disability parking badges. It's a legal definition, and it's not a very high hurdle to get over for an employee. And employees also know, because of the disability discrimination legislation has been around for a while, common knowledge is that you'll get more money for a disability claim than you would for an unfair dismissal. And if people have got less than 2 years service, they're going to bring a disability claim because they can't bring an unfair dismissal claim. So getting absence management right is important where anybody's got 1 day of employment, let alone 2 years, because of the threat of a disability claim. Now, dealing with absence where it's short-term and persistent takes a different approach to dealing with long-term absence. Medical evidence and understanding the medical condition is going to be much more important and crucial to the outcome of the process where it's a long-term absence. Dealing with short-term absence might mean getting under the skin of not just medical issues, but conduct issues. It might become a disciplinary matter, and managing the process will look a lot different to handling a long-term absence. So my advice with health problems, health issues in the workplace, absence, is to take advice from somebody like me about the process and about the communications before you get anywhere near dismissal. We will drill down into this more when we come on to our Retain webinar. So we've got some questions now, moving on to the topic of release. Some more quizzes for you.
Thanks. So yeah, this is the last set of questions that we have, and it's all about releasing employees and when they exit your business. So the first one is, which of these is not considered an unfair reason for dismissal in the UK? Is it membership in a trade union, poor job performance, pregnancy, or whistleblowing? Yeah, so everyone got it right. It is B. Poor job performance is not an unfair reason for dismissal in the UK. And then the second question is, in the UK, employees are protected from unfair dismissal from the first day of their employment. Is this true or false? So most people said true and a couple of people said false. It's actually false. Unfair dismissal rights kick in after 2 years of employment with an employer. And then the third question is, what is the maximum compensatory award for unfair dismissal in the UK? Is it 25,000, 50,000, 52 weeks gross salary, or D, there is no maximum limit? So most people said D, but it's actually C. It's either 52 weeks gross salary or £105,707, and it's the lower of the two. So there is a maximum limit on compensatory award. And then lastly, in the UK, employers can dismiss an employee for any reason during their probationary period. Is that true or false? So it's actually false. You can't dismiss someone if it's for a discriminatory or unfair reason, even if they're in their probationary period. So I'll hand it back to Liz now.
Keep that slide up for a moment, would you, Risha?
Yeah.
So there's a few issues that have just cropped up, I think, in that slide. So in the first question, what is not considered an unfair reason? So we have to think about the law on unfair dismissal, which we'll come on to think about in more detail in our release webinar. The law on unfair dismissal, as most people understand it, kicks in after 2 years of employment. So you have to be really careful about having a fair reason and a fair process after 2 years. Why? Because there is what I call vanilla right to claim unfair dismissal from 2 years on. These other areas, membership of a trade union, pregnancy and whistleblowing, are all what we call automatically unfair reasons for dismissal. So even below 2 years, if somebody is dismissed for one of those reasons and the tribunal satisfied that the reason was that reason, then it's an automatically unfair dismissal. They don't need 2 years service to bring that claim. So it's a slightly different picture for those reasons. In probation, we don't talk about unfair dismissal because it's well within the 2 years. But any employee or worker has the right to not to be treated in a discriminatory fashion, including being dismissed for discriminatory reasons. So discrimination is relevant from day one of the employment. So slightly different picture for different types of claim. Okay, I'm going to move on now to look at this area of releasing people and some of the key considerations. So, as with most things, the terms of time to say goodbye. Your employee or worker might be saying goodbye to you. They found a better offer, or there's a reason why they're leaving. Or you may have to say goodbye to them by giving them notice of ending their employment. It can be on good or bad terms. Hopefully, if we've done all the rest of it right, it won't be on bad terms, and we won't be lying awake at night worrying about an employment claim being brought against our business. However, we know that in real life, we can't guard against people feeling aggrieved, however well we think we've done things, however we've tried to end on good terms. And so it's important to protect our business by making sure we've taken the right steps when ending employment or when somebody resigns. So moving on. Oh, sorry, we're going to look at these areas. Sorry, ending employment, the key steps there, competition, confidentiality and intellectual property, because these are areas that we need to make sure that we protect. So there are various ways of ending an employment relationship. These are the key ways. Dismissal by the employer, which is either on notice or without notice. And an employer can only lawfully end employment without notice if the employee is guilty of gross misconduct. Resignation by the employee, again, either on notice or without notice. And then an employee can lawfully end the employment relationship without notice in circumstances where they believe they have been constructively dismissed. Otherwise, they legally owe the notice that is required, either statutory minimum or what's set out in their contract. Or employment might be ended by mutual agreement. Doesn't always have to involve a settlement agreement, but I would say 9 times out of 10, that mutual agreement is agreed is reached through a settlement agreement, which is a document that the employer requires the employee to sign to waive their employment rights against the employer. Note that the expiry of a fixed term contract is in fact a dismissal in law, and so the usual principles around unfair dismissal apply. Anybody who's employed under a fixed term contract which expires after 2 years will be dismissed in law if and the employer will have to, if they're challenged, will have to demonstrate a fair reason for dismissal and a fair process. Things to be wary of around ending employment. So we've said already, with less than 2 years, employers can be caught out by discrimination claims, whistleblowing claims, and automatically unfair dismissal claims. 2 years plus, the vanilla right to unfair dismissal, the claim that can be brought by any employee with over 2 years service. Statutory notice and statutory redundancy entitlement. So under statute, so this means not in your contract of employment, but under legislation, employees are entitled to minimum notice. It's a week per year of complete year of their employment. You can agree a longer notice period in the contract of employment, but you cannot go below the minimum notice. And if you are making somebody redundant, then they will be entitled to a statutory redundancy payment, and that will kick in after 2 years of continuous employment. Making sure that you have calculated the correct payments that are owed on termination of employment in relation to notice and holiday pay. So every employee has a statutory right to paid holiday. They're not entitled to be paid for unused holiday at the end of each complete holiday year. However, on termination of employment, they are entitled to accrued holiday pay for any holiday not taken, and that must be paid to them through the payroll. Can we move on? Please. Sorry, next slide. Oh, yes, there seems to be a delay moving them on, sorry. So, competition, confidentiality and intellectual property. I mentioned these areas earlier when we were thinking about contracts of employment and issues you might want to consider building into the contract beyond the legal requirements. Any business that is releasing an employee, whether they resign or their employment is ended by the employer, is at risk of competitive behaviour. But in reality, the more senior the employee, so if they're in a managerial capacity, if they're a director, if they carry responsibility for key relationships with customers or suppliers, if their role is very commercially important to the business, then the threat is at its highest. And for these types of individuals, it is commonplace for their contracts of employment to have very tightly worded non-compete and non-solicitation restrictive covenants. Those covenants will be time-bound, usually to 6, no more than 12 months in time. And as an employer, knowing that they're a threat to your business if they go and work for a competitor or if they start their own business, you will want to be able to rely on those covenants and take action very swiftly if they're breached in any way. The other key component of their contract, if they're senior and key to the business, will be a garden leave clause. And without a garden leave clause in their contract, you won't be able to put them on garden leave without their consent. But having an employee who's leaving on garden leave will mean 2 things. It will mean that they're still employed, so they still owe employee duties of loyalty and fidelity and trust to the business. But it also means that you can control their activity during their notice period. Usually this looks like making sure they stay at home, restricting their access to employee systems, having them not in contact with other employees and with customers, so that you, the employer, can control those relationships and make sure that you are protecting your business from any threat they pose once they're out there in the market. Confidentiality is a difficult beast. So all businesses have confidential information, and the types and extent of the amount of confidential information that employees are exposed to will vary by business and will vary according to their role. The basic position in law is that any employee only owes a broad duty of confidentiality to its employer whilst the employment relationship is ongoing. Once the relationship has ended, they owe a very, very limited duty of confidentiality to you. So it's really, really important to make sure that your contracts of employment go beyond the basic legal position, and that employees are contractually required to keep confidential all the information they have that is your business confidential information, both during employment and after employment ends, and that will be an open-ended obligation. So those post-termination obligations are the things you need to have your mind on in your contracts of employment. And again, it does no harm in any when you're releasing any employee, whether they're resigning or being dismissed, to remind them of their contractual obligations to the business, both their restrictive covenants, if they have them, and their confidentiality obligations. It's also critically important to get back any information that they have, whether it's in documentary form or paper form, or saved onto a laptop that they've been working on, making sure that they have deleted any company information from laptops or other devices that they may have worked on during their employment. Intellectual property, we touched on previously. Anything that your employees create for your business during the course of their employment is owned by your business. That's the basic legal position. But as we know, a lot of people are working very flexibly now. They're often working hybrid, sometimes at home, sometimes in an office. They're not necessarily under the gaze of their managers all of the time. They might be working very flexibly in terms of the hours, sometimes in the evening, sometimes at weekends. So the lines have blurred about the boundaries of work. Can we can we trust the basic legal position? I don't think we can. My advice is to make sure that in any contract of employment, the employee is told very clearly that anything they create during their employment is owned by us, their employer. So make sure that that's covered in the contract of employment and that it's clear and goes beyond this basic legal position. The second point to flag with you is that anything created by any third party, be that a casual worker under a 0 hours contract, a contractor, consultant, a freelancer, or any other third party that happens to come in and do something within the business. It might be an intern, student, volunteer, it might be a director of the business who's not a day-to-day employee. Any IP created by those individuals is not owned by the business. It's owned by them. So you should have written assignments of IP that are signed by those individuals that assign their intellectual property to the business. Fundamentally important. Can we move on, please, Isha? So that's the end of listening to me. I'm going to hand over to Isha to round off our webinar.
Thanks, Liz. So yes, thank you for watching. We hope you found it informative. And as mentioned earlier, we do have 3 more webinars. One on the 6th of December, 17th of January, and 14th of November. Recruit, Retain, Release. So please join us for those if you can. I'll send out more information later, and you'll see it on our LinkedIn and social media. But does anybody have any questions? I know Selena had a question. So I'll go to hers first. And Selena asked, if a temp joins from a recruitment agency, do we need a copy of background checks, etc.?
I would say yes. It may be that the recruitment agency has carried out those checks because they should be doing that as the employer of the worker. But I'm not an immigration expert, but my understanding is that any business, any company, any employer that has people working in its business should carry out checks on their own checks on that worker. So if the agency has carried out the checks, you can legitimately ask to see copies of those checks. I'm not sure that that is sufficient though for the purposes of the Home Office's requirements. And Samir, I'm happy to pick up on that question with you separately and check and confirm the position with you. But my hunch is that yes, you need to do your own checks.
Does anyone else have any questions? I can see Robert is typing. But if you do have a question, you can pop your mic on or raise your hand. Okay, so Robert's asked health issues post offer, e.g., what if they are unable to lift, having a bad back, job is required to lift?
I think that's a really tricky issue. So if you've offered somebody employment and unless you're going to carry out a medical post offer, which could be legitimate to understand any health issues and how they might impact the job and whether any adjustments are required. You mentioned a bad back. That could be a disability for discrimination law. And so the duty under discrimination law is to make reasonable adjustments for disability if that impacts the worker's role. You can probably see where I'm going to go with this. So that probably looks like advice from occupational health. The duty on reasonable adjustments is not to make any adjustment. It's adjustments that are reasonable in all of the circumstances. So that means looking at the nature of the bad back, the condition, how badly it affects them, and what would be reasonable as an adjustment for that business. And what's reasonable for, I'm trying to think of a massive employer, a British Aerospace would not be the same as what's reasonable for Joe Bloggs Plumbing that has, 20 employees and is a much more limited scope enterprise. So these things are very contextual, but I would say if there's a requirement to lift within the job, I think you need an occupational health assessment, medical fitness assessment before that person starts in the job.
Just got one more question.
Oh, sorry, I don't have volume on. Bear with me.
Oh, hold on. Can you hear me?
Yeah.
All right. Sorry. Thanks for that, Liz. I've got one question. It's quite a sensitive subject. If somebody's terminally ill and you've got a training program that lasts for a certain amount of time, how would that work?
In terms of what is when you say how would that work? What do you mean?
If somebody's got a life-limiting illness and they've got a certain amount of time, and you've got say a training program that lasts for a year that you need to have a year before you become productive in the company. Yeah. How would that work in terms of not finding out their health issues after the event you've offered them a job?
I've never come across that scenario. I suppose it is in theory possible. I think in reality, if somebody is terminally ill, I would imagine that's something that because they're going to have possibly treatment appointments and time off that is required. So I would anticipate that the employee would want to share that information at the earliest opportunity. I'd be surprised if they kept it to themselves deliberately. And knowing that information, you're going to be on notice that they have a disability. I think that it's very difficult for you to say no to the training. But it's a scenario that I've not come across, and I'd be interested if anybody else has got any other ideas. Yeah, Is it a reasonable adjustment to allow them to continue? I think that's the nub of it. And it may not be. But
right.
Humanely, that would be a very difficult decision to take, wouldn't it?
It would.
It'd be oh, bye-bye, Emily. Thank you for attending. It would be a business decision that you may be able to take in theory, but in practice, I think it'd be a very difficult decision to take. But I'd be surprised if you ended up if somebody had a terminal diagnosis. I think the reality is they would want the employer to know. I think they'd be very deceitful. I can't understand why somebody wouldn't want the employer to know before they took on employment, because they would want support. Yeah.
Okay. I suppose. Yeah.
I don't think that fully answers your question, because if you know pre-offer, then you've got you've got information that you've got to make a decision on, haven't you? So that's not easy either.
Yeah. What I was trying to do, I mean, I have been in that situation before, previously. Not quite that scenario, but in terminal illness. However, the health issue, not knowing the health issues until after you've given an offer, I'm sort of, probably wrongly, but I'm incredulous that's the way it is in some respects. But on the other hand, it does avoid the discrimination against disability.
Yeah.
And it's a difficult line, isn't it? Yeah.
And Melina says, her dad, I'm sorry to hear that. Her dad had a terminal illness and employers had great difficulty getting rid of him. And I think that is because it will class as a disability, and the disability in itself is not going to, I mean, your question is about training, if they're new. So if somebody's employed, already, and they have a terminal illness, that is not a reason to dismiss. It would be discriminatory reason if it was the reason. But in circumstances where you're taking somebody on and they have a terminal illness, I'm not sure that is sufficient to get you around the discrimination legislation, unless you see, if you're a small business, you have the defence of discrimination being your defence is that whatever decision was taken was proportionate decision, and it was a legitimate aim. So you do have scope to argue that as a small business you have limited funds to invest in training, and there has to be return on it. If somebody's not going to be with you for more than a year, if that's what they've told you, they're not going to be able to complete the training. It's going to be a waste of resources, and they're not going to be there to carry out the role anyway. Yeah. But I think it's a very difficult scenario.
I do have one more. Thank you very much again for that.
Yeah.
I do have one more question on recording contractual changes. So obviously you have your original contract that's not touched, but you make changes to that contract over the employee's life at the business. And how would you record that? Does it need to be, obviously you need to record it, but what's the best way to record that in terms of the changes and everything in their role?
So I think it depends what the change is. I think if it's an update, if it's an increase to salary or additional benefits, but they're in the same role, you can just do it by letter and have them sign the letter. If they're moving into a new role through promotion or internal recruitment, then I think it looks like a new contract of employment for that new role. Right. Not least because with the new role, particularly on promotion, you might be considering things like restrictive covenants. Even if they're there already, you might be reviewing them, and so it makes sense that there's a new contract of employment, not a new contract, but an updated contract of employment with continuous employment still applying, obviously, but an updated contract. Their notice period might be getting longer, for example.
So I'm just writing this down. Motion change. Brilliant. Thank you very much for that. Okay. That was very, very informative.
Glad you enjoyed it. Thank you everyone for attending. Please do feel free to sign up for our forthcoming seminars, and do spread the word. We'd love to get people who need this information to be in front of us when we do the next seminar on the 6th of December, I think is right. Okay, fantastic. Thanks everyone for coming.
You. Cheers.
Hope to see you soon. Bye-bye.
Thank you. Bye-bye.
Bye.